most significantly for a lot of the clients that we deal with, it does not apply to office spaces or job centers. Also does not apply to manufacturing, processing, distribution, production, or utility facilities. Although with office spaces and businesses in general, the state is still recommending that to the extent possible, people work remotely. And within the last couple of days, there have been orders in other states, including California, that place even more restrictions, that limit the businesses that can be open to those that are providing essential functions. And so again, this is a rapidly evolving situation. It would not surprise me in the least if there are more states that adopt restrictions similar to that. So we will try to keep everyone posted as things come out. Just to give you a little overview of our program today, we have a few different segments of it. The first portion, you'll hear from Christopher Schuele and Ashley McNulty about legal issues under WARN Act, ADEA, ADEA, and OSHA related to the coronavirus. Christopher is an associate in our group. He does a lot of litigation and counseling work, and has a focus on government relations issues and a variety of other subjects that are related to labor relations. Ashley is also an associate in our group, graduated from Notre Dame Law School and spends a lot of her time counseling clients on a variety of labor and employment issues. The next subject is legal issues arising under Wisconsin's unemployment insurance law and under federal and state wage and hour laws. And Rob Sholl will be presenting that. In addition to being my predecessor as the head of our labor and employment group, Rob has, I think, too many honors and awards to list here, but he's been recognized in best lawyers, chambers, super lawyers, a variety of other accolades. He's involved in a number of different organizations that deal with labor and employment law, and so he will be talking on those subjects. After Rob, there will be a section which is one of the ones I know that many people are interested in, given the very recently passed federal legislation on administering new emergency federal sick leave and the public health emergency FMLA leave. That will be presented by Michael Gentry, who's an associate in our group who, prior to joining us, worked for the state and handled a bunch of employment matters for different state agencies. He does litigation and counseling work in a variety of areas. And the other presenter for that topic will be Shannon Toole, who's also an associate in our group and works on a variety of different litigation and counseling matters in the labor and employment area. And finally, last but not least, we're fortunate to have with us Jesús, who is with the Wisconsin Equal Rights Division, and he will be providing an update on what's happening there. Prior to joining the Equal Rights Division, Jesús worked at Northwestern Mutual, where he was their lead employee relations consultant and equal employment opportunity officer. Has his law degree from Duke University and undergraduate degree from Princeton. And he is the Equal Rights Division Administrator at the ERD. And just in general, I know there are a lot of topics, that we expect to cover today, including leave, time off, flexible scheduling policies. Are there exceptions for an outbreak that's identified by the CDC? We're looking at a variety of different situations in which employees work remotely and how you handle timekeeping to the extent those employees are non-exempt. reductions in hours for exempt employees. I know I've had some calls from people who are not covered by the act that was enacted this week at the federal level, and questions about what, if anything else, they should be providing in terms of leave. The EEOC has recently updated its pandemic preparedness in the workplace publication, which has a variety of questions and answers about issues. They've added some information to that is related specifically to the coronavirus pandemic. The WARN Act, there have been a number of questions related to that. In addition, I know of clients looking at business interruption insurance, supply chain issues, contract issues there. And all of these things are things that people are trying to juggle, along with trying to be proactive and to take reasonable steps to protect employees. So with that, I will turn it over to Christopher Schuele and Ashley McNulty for the first portion of our presentation.
Well, good morning, everyone. Thank you very much, Chris, for leading this off. My name is Christopher Schuele. I'm an associate in Reinhardt's Labor and Employment Department. And this is Ashley McNulty, who is also an associate in our Labor and Employment Department. We are here to speak to you about a number of different issues related to the coronavirus response by employers, chief of which issues under the WARN Act, the Americans with Disabilities Act, the Age Discrimination and Employment Act, and OSHA, the Occupational Safety and Health Act. I'd like to start with the WARN Act and talk a little bit about what the difference between terminations and temporary layoffs are, and how that will affect your business's response and obligations under the WARN Act. As many of you already know, the federal WARN Act requires covered employers to provide employees who suffer an employment loss with a certain degree and amount of notice, 60 days of notice. And that notice requirement is triggered if there is an employment loss suffered by 50 employees who comprise at least 33% of active employees, full-time employees, or at least 500 employees at a business. When those notice requirements are triggered, a number of different steps come into play. But here, with the coronavirus, we find ourselves in an interesting situation where the statute itself provides certain exceptions to the notice requirement, but it's not entirely clear how those exceptions will be applied and how courts will interpret those exceptions given the coronavirus outbreak. One of the exceptions that I'd like to speak about today is the unforeseeable business circumstances exception. That exception is one that does seem to apply very well to this situation. It's an exception to the notice requirement where there are business circumstances that were not reasonably foreseeable at the time that notice would have been required. So in other words, 60 days ago, if employment losses are to be suffered today, for example. That does seem to be an exception that would apply to this situation. However, the exception doesn't totally absolve the employer of those notice obligations. Notice does have to still be given to employees as soon as practicable. So at least insofar as planning for employment losses in this environment, it is advisable to contact your attorney to talk about how best to structure your reductions in force if that is a decision the company is making. Another exception to the WARN Act is the natural disaster exemption. This one is a little bit, it seems to fit this situation, at least on its face, but the statute itself lists a number of different examples of what sort of natural disasters would qualify. Those include floods, earthquakes, droughts. These don't exactly fit the circumstances we're in now as far as a national pandemic. It's yet to be seen whether courts will apply this exception to this set of facts, but there's another exception that, again, could apply in this circumstance. Now, those exceptions would all apply if there is indeed an employment loss. However, temporary layoffs are not an employment loss under the Federal WARN Act, at least temporary layoffs that last 6 months or less. If your business is considering laying off employees for less than 6 months, and that is considered reasonable by a reviewing court or by the company at this stage, then there would be no notice requirement. However, at this point, as all of you are aware, the question of the hour is how long this state of lockdown is going to last. Is it going to be a month, 2 months, 5 months, 6 months, 7 months? We're getting into some tricky territory. So again, please consult with an attorney to talk about how best to move forward with your WARN Act notice obligations in the context of terminations or layoffs that last less than 6 months. We've been helping a number of businesses navigate this particular question already, and we'd be more than happy to provide you with additional guidance as well. In addition to the Federal WARN Act, there is the Wisconsin WARN Act that provides similar requirements and exceptions to the notice requirements. And again, complying with both of those pieces of law will be critical and important for employers moving forward. The very conservative approach would be to provide notice as soon as possible. But again, there are steps we can take to work with you to make sure that we're complying with these pieces of law moving forward. I'd now like to turn it over to Ashley for a little guidance on the Americans with Disabilities Act.
Hi, everyone. So as Christopher was talking about, what you can do to prepare for layoffs and terminations, this section on the Americans with Disabilities Act and kind of from here on out are talking about managing your workforce on a day-to-day basis. And with the Americans with Disabilities Act, it prohibits, the standard is that it prohibits people from asking about employees' underlying conditions, any disability-related inquiries or medical examinations. So with that being said, Chris Banaszak mentioned that the EEOC has come out with pandemic guidance, and it has now been updated and tailored to discuss COVID-19, the coronavirus. So with that being said, I think a lot of concerns that employers have deal with, how can I approach employees, because the media and even, government advisory publications have been saying things like send people home. These are the categories of people who are at risk. So just kind of navigating that is probably very difficult for you as you try to manage your workforce. But, even though your intentions probably are very good when it comes to asking people, how do you feel today? Or do you have an underlying condition? You have to be, or even, singling out people based on whether or not they're more likely to come in contact with or be susceptible to COVID-19. You have to be careful. So I think that one thing that people have to do is, you can't realize that you can send sick employees home, and that the EEOC has said that that is not in violation of the Americans with Disabilities Act. Because this is a pandemic, you can take people's temperatures. However, if you're going to take people's temperatures, you cannot single out people based on protected characteristics. You can just, detect, do you have symptoms, and then take their temperature. But be careful, because we know that COVID-19 takes anywhere from 2 to 14 days for people to show symptoms. So you could be walking up to someone, they may not have a fever, but they still might have the virus. So, just think critically about whether or not that's something you want to be doing, and especially getting within 6 feet of someone during this time. And if you do take someone's temperature, that would be considered a medical examination under the Americans with Disabilities Act, so you would be required to keep those results confidential. And I think just from a practical standpoint, you don't want to take someone's temperature, and if they've got a fever, tell everybody in the office, because that would be very unreasonable and likely to send fear. What if that person has a fever and it's something completely unrelated to COVID, and then you've got worried employees on your hands? So I just think to maybe take it slow and, reassess and think, is that something you really want to do, even if the EEOC says it's okay? Some things you can also do is you can ask benign questions about, how do you feel? Again, ask everyone. You can say, have you traveled anywhere? I think the EEOC has laid out some questions you can ask people to determine whether or not they might be absent. You can't say, hey, I know you have this pre-existing condition, or you look like you might have a pre-existing condition, or something of the like, and do you think you'll be absent? That would not be good. But asking people, is there a reason that you might need to stay home, or your children out of school? They have kind of an inquiry where you ask yes or no questions, and that way you're not getting into the nitty-gritty about what people are dealing with on a health and medical level. It's just, will you be here? Shutting down things like traveling and seeing about people who maybe take public transportation and get to the workplace. Those are things that you can ask. Now, if you would like, the EEOC guidance is very helpful and it's accessible online. But one thing that both the CDC and the EEOC make clear is that you can't single people out based on their age, likelihood to have a pre-existing condition. And also, one thing right now is singling people out based on their national origin or any other protected characteristic. We know where the virus originates, but you can't, send people home based on, the fact that they are maybe that they're from Asia or likely to have traveled there because they have family over there. It's travel bans are okay, saying people that you cannot travel, but singling people out because of their characteristics is not. So
yeah, and just to build on what Ashley's just spoken to, I think it's key to draw a distinction between asking questions related to what people's activities have been over the last couple of weeks and what their underlying medical conditions may be. There's a lot of information circling at this point regarding what sort of underlying medical conditions will make people more or less susceptible to the coronavirus. But as an employer, it's not your responsibility, or you're not able, rather, to make judgment calls about whether or not someone is susceptible or not, and eliminating those people from the workplace. Now, if someone is showing symptoms of high fever, sneezing, coughing, it is absolutely within your right and your responsibility as an employer to send those individuals home. But again, there's a fine line, and the attorneys at Reinhardt can, of course, help you draw that distinction. Dovetailing a bit back to the WARN Act analysis that I spoke to earlier, this is a time where a number of businesses are contemplating mass layoffs, even mass terminations. We advise you to make sure that when those termination decisions are being made, that there is not an adverse impact on protected categories of individuals. For example, individuals who are 40 years of age or older would be particularly susceptible to that sort of adverse impact in this climate. Any sort of mass layoff should be done based on non-discriminatory reasons, of course, and tailoring those reasons to fit the circumstances is critically important at this time when decisions are made at a very rapid pace.
And kind of to go off of Christopher's comment about people who are 40 and over and making layoffs, I think so let's say that your business depends on travel, and you have, it's kind of like the heart and soul of your business, and people need to go across the United States, whether or not, that's even possible right now. Let's just assume that it is, and think, well, I don't want all of my employees who are over 40 or over 60 or who have a condition to hop on a plane right now, but everybody who's under that age or everybody who doesn't have a condition certainly can continue to do their jobs. Or maybe you think about cutting shifts for people because they're older. You really can't do that. It's got to be kind of like an all or nothing approach when it comes to, age discrimination. You can't just single out people because of their age when you're doing, layoffs, but also managing your workforce during this time.
And one final comment on the point Ashley made earlier about taking temperatures. Again, the EEOC and the CDC has given guidance stating that employers can indeed take the temperature of their employees to detect symptomatic individuals. But I would like to remind employers that not all individuals exhibit symptoms in the form of a fever. So a temperature test is not a foolproof means of determining whether someone has the coronavirus or not. Additionally, it is a decision that employers can make, but it's going to have less tangible effects rather on your employee base. It's going to change the tenor and tone of how we relate to our employees. That's a decision that employers are entitled to make, but understand the consequences before doing so.
So now I'm going to talk about the Federal Occupational Safety and Health Act. Now, chances are that the state that you live in also has some sort of approved plan with OSHA, but I'm going to talk about what the federal law requires. And for those of you who are based in Wisconsin, if you ever need to get in touch with someone from OSHA, we're in what they would say is Region 5. But, taking it, I think that you should look in to see whether or not your state has requirements as well. But like I said, I'm just going to talk about the federal general duty clause. So under OSHA's federal standard, employers have a general duty to keep their workplaces free from hazards that are likely to cause death or serious harm or are currently causing death or serious harm. And how you fulfill that standard and take steps depends on what type of workforce and what type of workplace you have. So, right now, just like the EEOC has come up with guidance, OSHA has, the Occupational Safety and Health Administration has come out with guidance as well, and it's updated to reflect the steps you can take when dealing with coronavirus. And so they categorize workplaces based on risk, and so it goes from, I think it's low to medium, high, and then very high. So some examples of those workplace examples of low risk workplaces. Those would be workplaces where you're unlikely to come in contact with the general public. And then medium, so in the face of an outbreak, those are places where you do come in contact with the general public, and coming into contact for OSHA purposes means within 6 feet. And so when there are known or suspected cases of an outbreak in your area, so that means people who come in frequent contact with travelers right now, people that work at airports, maybe even people that work at public schools or private schools. Let's see, what else? Daycare centers, grocery stores. So in an area like Milwaukee County, when we know we have cases that have broken out, people that work with the general public, that would be considered a medium risk area. And then high risk is hospital support staff, people that work in a mortuary, and they're dealing with maybe suspected cases, not actual proven cases of COVID-19, but people, maybe hospital transport workers or ambulance personnel. And then very high risk are people that work directly with patients, dentists, nurses, doctors, people that handle COVID-19 specimens, so people that work in laboratories, and others who have been exposed to COVID-19. So that's kind of how OSHA breaks down what your risk is, and then what your risk is depends on how you take steps to comply with that general duty standard in the workplace. So when you assess your risk, obviously that's a great guideline, but you have to think about the job, and then you maybe also have to consider the home life factor, factors that could impact the risk of your employees. So maybe your workplace is a medium or low risk type of workplace, but you know that someone is married or cohabitates with someone that they do work in a laboratory and they have been handling samples. So those are other things to consider when you come up with a pandemic preparedness plan. And these plans, which employers should work to develop, and if you need help developing a workplace preparedness plan, feel free to contact one of us here. We can help you develop that and give you some guidance. But you should consider how your workplace will be impacted by things like absenteeism, and relaxing or maybe developing a pandemic absence policy. Thinking about social distancing. So how are you going to implement that in the workplace? As you can see, we're practicing it right now and around the room. So just taking steps to make sure that people do not come within 6 feet of one another in your workplace. Staggered shifts, depending on what line of work you're in, that could be another thing you should address. And then also cross-training workers if you're dealing with a workforce for whatever reason, if it's people choosing on their own to stay home, or you've taken steps to make people stay home, or you've laid off workers. Cross-training workers to do more than one task may be something you can do. At a very minimum, no matter what risk level you're at, employers, and OSHA has said this from the very, very beginning, but employers should be educating employees about what COVID is, and then teaching them about hand washing, coughing and sneezing etiquette, and then sanitizing, just making hand sanitizer available, making towels and tissues for people to use to, carry out these steps available, and then making sure that they don't have to touch waste baskets. That's just something at a minimum employers can do to make sure that they comply with OSHA, the general duty clause, discouraging the use of shared items in the workplace. So maybe making sure that if there's usually a common phone or a common computer that people use, I would really caution against that right now. Encourage teleworking is something you can do as part of your pandemic preparedness plan. And just, I think, the more you educate employees, the less likely they are to be fearful, and actually probably the more likely they are to show up if they know that, they do work in a low to maybe medium hazard workplace. Another thing to consider is, what do you do as an employer to comply with this general duty clause if people in your workplace show symptoms? So the key here is to isolate people. If you ask people who show up to work and maybe they are coughing or sneezing, or they say, I have a fever, the first thing you should do is probably remove them from contact with other people. OSHA has mentioned making a designated isolation space. You can ask people who show symptoms to wear masks or maybe other equipment. You can't force them to wear it, but it's highly recommended that they do so. Putting up barriers if you can't make a designated isolation room for people who show symptoms, to keep them there before they can be removed from the workplace. Putting up barriers and guards. And another thing you can do, because some of you may rely on staffing agencies, and you contract staffing agencies to supply your workforce, you should really make sure that your visions are aligned with how you're going to handle this pandemic and what their pandemic preparedness is, because you certainly do not want, if you're taking all these steps to isolate people who are sick, if they're not taking any steps and someone shows up at the workplace, that kind of maybe counteracts all the steps you've taken. So as part of your general duty, you should make sure that your visions are aligned with regard to treating and keeping people who show symptoms off of your property or away from other employees. So those are just some examples of how you can comply with the general duty clause. Now, one other thing is, depending on your workplace, you might have to implement what OSHA calls personal protective equipment, and that means fitted equipment that prevents the spread. So face masks, ventilators, respirators, these types of things are things you can use to help comply, and depending on the risk in your workplace, they might be very necessary. And if you are going to provide personal protective equipment, then you have to make sure that it's fitted and that it's based on, the hazards to each worker. So giving someone, in our profession and saying, here's your protective equipment, wear this mask, it might not really do anything, but if you're a healthcare worker, making sure someone has a respirator, and then it's your job as an employer to make sure the respirators fit correctly, and there's OSHA resources on respirator use and training employees how to use those respirators. And, depending on your workplace, it's not a one-size-fits-all approach, and I think as you'll learn, a lot of this is not. So please feel free to reach out to us, and we can help you navigate how to comply with these federal and state standards for keeping your employees and workplace safe. Thanks. Sure. Okay. So, Christopher, the first question is, what are my obligations to provide accommodations to employees who work from home?
Well, I think that the answer is sort of in the question there. I think that individuals are more and more likely to work from home as this pandemic continues to move on. Working from home is a reasonable accommodation that the EEOC has highlighted in its guidance, and many jobs now today can be done from home, ensuring that technology is adequate, that individuals are able to access all of the necessary aspects of their job remotely, I think is critical for this. Understanding also that unpaid leaves of absences, and we'll get to the new piece of legislation that has just passed through the House and the Senate, has been signed by the President a little later in this presentation. But leaves of absence when used by employers as a reasonable accommodation can also be something of a reasonable measure to take during this time of the coronavirus outbreak.
I'll take this next one, and it is, do I have to excuse the elderly and those with underlying conditions from working? So, not a one-size-fits-all here, but if the elderly want to work, I think that you should be sure to, accommodate that request and not say things like you cannot work because you are over 40 or because you are 60. And I think that if people with underlying conditions say, I want to work to the capacity that I can, this goes to what Christopher was just talking about, which is reasonable accommodations and providing them with accommodations so they can do that. But if people who are of these more susceptible groups of people, that if they say, I have concerns and I do want to self-quarantine for 2 to 14 days, as an employer, I think that, right now maybe coming up with policies that are a little bit more relaxed and that allow them to do that is the way to go. But if you, just be sure that you work with employees, and I think it comes down to, not singling these people out based on their characteristics, but working with them if they ask for reasonable accommodation during this time.
And again, it's a tricky balance between changing policies of the company as a whole versus dealing with individual requests for specific accommodation based on specific needs. So again, these are waters that we can help you chart together. But much of this, I think, is happening on the fly.
Yeah. And then the last question is, do I have any liability if someone in my workplace gets coronavirus? And again, that's a question that I think, because this is ever evolving. So what that looks like in the future, if people say, I contracted this at work and you didn't do enough to protect me, I think that first of all, you can take the steps to comply with OSHA and any state-approved occupational safety and health plans. Now, one thing employers should consider is the fact that, maybe someone brought corona or into the workplace and then another employee gets it. There may be some workers' compensation issues there. So that just might be something to consider going forward, and how you as an employer may have to, provide relief to employees who contract corona or COVID in the workplace. And that's our presentation.
Thank you very much for your time, and we'll now turn it over to, I believe, Rob Sholl.
And while they're switching spots here, I want to apologize for losing the audio in the first few minutes of our presentation, especially to Chris, since it was his introduction. And what you also may have missed, for those of you on an iPhone or an iPad, you can toggle between the two screens, either the webcam view or the presentation view, by swiping your screen. And there is also the presentation handout you can download from the webinar platform. Thank you.
One other thing I just wanted to mention before Rob begins too is if you have any questions during the presentations, you can use the questions area on the webinar platform to submit your inquiry. I think some people have been doing that already. To the extent that we don't answer those questions during the presentations, during the webinar, we will try to follow up with people to do that.
Good morning, I'm Rob Sholl. I've been practicing labor and employment law for over 30 years, and I've truly never seen anything like this. In terms of its impact on the employer-employer relationship, we are in very uncharted waters, and the employment law that governs this emerging situation seems to change on a daily basis in response to COVID-19. So may we live in interesting times. I'm going to talk about two things. First, the legal issues that arise under Wisconsin's unemployment insurance law. One of my colleagues forwarded to me last night a Milwaukee Journal Sentinel article that said that there have been 30,000 new unemployment insurance claims just this week. And that was only presumably through Wednesday or so. So unemployment insurance benefits is really an issue that's getting a lot of attention. So I'm going to start with a discussion of eligibility issues. Will workers qualify, for example, if the coronavirus causes their employer to shut down operations? Yes, they'll be eligible for unemployment insurance benefits. What if the employer lays off some employees due to the loss of production or business caused by COVID-19? Again, will employees be eligible for unemployment insurance benefits? Yes. And the principle behind both of these yes answers is that unemployment insurance benefits are available to any individual who is unemployed through no fault of that individual. What if an employee chooses to self-quarantine because of COVID-19? Says to the employer, I'm not coming into work. I'm going to be at home, and I'm not going to be able to work at home. I'm just too worried about this situation. Will that employee be eligible for unemployment insurance benefits? In most cases, the answer to that is no. Again, unemployment benefits are available only to individuals who are totally or partially unemployed due to no fault of their own. And in this case, the conclusion would be that they're there because of some choice that they made. The employee would be choosing not to work and therefore would be ineligible. What if the employer requires quarantine? Would the individual be able to collect unemployment insurance benefits? In this situation, probably the answer is yes. If the employer is requiring individuals to stay home and doesn't offer telework, the individual might be eligible for benefits if they're otherwise eligible under the UI law. What if there's a mandatory quarantine that's imposed by a medical professional or by a governmental entity, and the employee's not self-quarantining but staying home because of this medical professional or governmental entity edict? Are they eligible? That is a little more complicated in terms of an answer. The answer is maybe. If the employer has instructed this individual to return to work after the quarantine is over, and the employee intends to return to work after the quarantine ends, that's probably a temporary layoff, and the employee is eligible for benefits. Another eligibility issue, what if the employee is home ill because of COVID-19 and unable to work, are they eligible for unemployment benefits? The answer is no, and that's because the federal law requires that claimants be able to work, available for work, and actively seeking work. So if someone is home ill, they're unable to work, and they would not meet criteria for eligibility. Turning to the next bullet point then, waiting week. Is there still a waiting week for those applying for unemployment insurance benefits in Wisconsin? That's in limbo. Currently, Governor Evers has asked the state legislature to repeal the 1 week waiting week. He asked for the same thing a year ago, and the Republican-controlled legislature did not adopt that suggestion. Things have changed. And we'll see what the legislature does now. But obviously, the purpose or rationale behind this is Governor Evers wants to act quickly to waive that 1 week waiting period for benefits so that much needed unemployment insurance benefits can get to workers more quickly. The topic not on my bullet points, and that's search requirements. In the midst of COVID-19, is an employee required to search for work during the COVID-19 epidemic? The answer to that is no. On March 18th, which I think was 2 days ago now, Governor Evers issued emergency order number 7. And in that emergency order, he waived the work search requirement. So UI claimants don't have to conduct at least 4 weekly work search actions during this COVID-19 emergency. Governor Evers' order went into effect immediately and is going to remain in effect during the duration of the COVID-19 public health emergency. And then finally, impact upon unemployment tax rate. Is this going to result in an employer's unemployment taxes increasing? Probably yes, obviously. Contributory employers will see an increase, I think, in their tax rate, and that will result in higher taxes. Reimbursable employers will be charged dollar for dollar for the benefits paid, and that could result in higher than expected unemployment costs. So turning to my second and last topic, and this one will be brief, just wanted to address very briefly legal issues arising under federal and Wisconsin wage hour law. Immediately after I'm done speaking, Michael and Shannon are going to talk about the Families First Coronavirus Response Act. We'll talk about the Paid Sick Leave Act, and they'll talk about the expansion of the FMLA to include a new category of leave, public health emergency leave. And leave taken under both of those portions of this new act are generally paid leave. In other words, an employer is going to have to pay an employee even though the employee is absent and is not working. But at least with respect to exempt employees, the wage hour laws may also require an employer to pay an employee even though the employee is absent and is not working a full work week. And that's what I'm going to discuss very briefly now. The context for this part of my discussion is you have to understand the difference between exempt employees and non-exempt employees in order to ensure you're compliant with the Fair Labor Standards Act. So if you're considering not paying employees for time missed from work, the first question to ask yourself is, am I dealing with an exempt employee or a non-exempt employee? With respect to non-exempt employees, generally employees who are non-exempt and who are not working don't have to be paid. But obviously that's changed now with this new law. Employees who qualify for paid leave under the Families First Coronavirus Response Act are going to get paid as long as they're eligible for pay under that act. But once they exhaust the paid leave under this new act, then non-exempt employees will not have to be paid if they're not working, or to put it conversely, only have to be paid for hours worked. Turning then to exempt employees, remember that an exempt employee under wage hour law receives his or her full salary for any week in which he works or she works at all, regardless of the number of days worked and regardless of the number of hours worked. Exempt employees are generally paid on a salary basis, regardless of hours or days worked, and that's known as the salary basis test for exempt employees. Now, even with respect to exempt employees, and again, setting aside the paid leave provisions of this new act, if an exempt employee doesn't work at all during a specific work week, they don't have to be paid. Now, again, there's going to be an exception with the new act, but once an exempt employee exhausts paid leave under the new act, but doesn't work any hours during a work week, they wouldn't have to be paid. But the point I really am trying to get across here is, what if that exempt employee works some hours during a work week? What if you have a situation where the employer says, you know, our business is down, you don't need you here all week, you only need to come in 2 days this week, and that's all the work I have for you. In that instance, what the wage hour laws would require is that you pay that exempt employee the full salary, because the 3 days in my example that employee is not working was occasioned by the business operating requirements of the employer, and not, you know, the employee deciding not to work those days. So that's my quick summary, and now we'll turn it over to Michael and Shannon to discuss the new law.
Good morning, everybody. I believe Michael is going to kick us off. Michael is going to be joining us from home. Michael, are you on the line?
Hi. Can you hear me?
Awesome. Yes.
All right. Well, hi, everyone. I'm Michael Gentry. I'm an attorney with Reinhardt's Labor and Employment Practice as well. Thank you for indulging my extended social distancing today. I do apologize we could not get video to work for today's presentation on short notice. As Rob mentioned, today I'm going to be talking through the nuts and bolts of the Emergency FMLA Expansion Act, which is one piece of the Families First Coronavirus Response Act, the new legislation that President Trump signed into law on Wednesday night. We should have time for a few of the dozens of questions that we received in the last few days at the end of the presentation, and thank you very much to those of you who have submitted your questions. After I speak, Shannon is going to be speaking about the new Emergency Paid Sick Leave Act as well. There's obviously a lot of content to get through here, so we'll do our best to get up through all of it. As Chris Banaszak mentioned, anything that we can't get to today in terms of questions, we'll do our best to get back to you about this coming week. And for those of you who would like more immediate answers to some of your questions, I'd recommend that you go to our website where we have set up a COVID-19 Intelligence Center, where we've gathered together all of our e-alerts and other publications advising companies how to deal with the many evolving aspects of the COVID-19 pandemic, including the 3 articles that we've already published about the new law specifically itself. So the Families First Coronavirus Response Act, along with expanding the FMLA, it provides for a whole new category of paid leave, paid sick leave, which I mentioned Shannon will describe. It also provides for tax credits for small businesses to help compensate them for the new paid leave, and expands unemployment insurance in the form of $1 billion if states ease the ability for employees to get those benefits. And like Rob Sholl mentioned, Wisconsin's Governor Evers has already taken some steps to put Wisconsin into that category to ease those to allow more employees to get those benefits. We won't touch on those issues specifically today, but that's an overview of the entirety of the Families First Coronavirus Response Act. As for the FMLA Expansion Act, we'll go through the nuts and bolts of it and try to answer questions about under what circumstances does it apply, who it applies to, and answer some of the questions that are outstanding, but also raise some issues about questions that we probably can't answer right now because we're still waiting for guidance from the Department of Labor. As for the current status of the legislation, as I mentioned, President Trump did sign it into law on Wednesday night. When we planned this webinar just a couple of days ago, put the slide together, it was at that point still unclear what version of which chamber of Congress's bill was going to become law. Ultimately, the Senate did decide to pass the House bill as is, and then is currently taking up its own measures to address potential other holes in the House's legislation, which I'll touch on briefly later when we discuss measures that are designed to ease the financial burden of the new law on small businesses. So the FMLA Expansion Act, in essence, it uses the existing framework of the FMLA to provide a new type of leave to employees, what's called public health emergency leave. One based on whether employees need time off to care for their specifically minor children because of those children's schools or daycares being closed because of the coronavirus, which of course pretty much all schools and daycares are closed now. Employees qualify for the new leave if they have worked for their employer for at least 30 days, and they must need the leave for the qualifying need of taking care of their children due to the closure of the daycare or school. In terms of which employers the law applies to, you probably know it only applies to employers who have fewer than 500 employees. So any employee working for a company larger than that, at this point, there is no federal law requiring a paid leave for any of those employees. That's our current understanding. It's subject to change based on potential Department of Labor regulations. And in terms of counting, the number of employees for deciding whether or not there are 500 employees, our understanding is that all employees should be counted as of the time of the leave request or the time that the leave determination is made. It's also our understanding, and this gets back to a little bit what others have talked about in terms of laying off individuals, is that if an employee is merely laid off or is simply not working but is still technically employed, that person would both be countable for purposes of determining whether the company has 500 employees, and it's our current understanding that that individual would also be entitled to the new leave of the public health emergency leave under the expanded FMLA. One of the questions that has come up is the question about paperwork. Obviously, when we're talking about leave under the general FMLA, where people take leave for a serious health condition or for birth or adoption, there's significant paperwork that's established, and HR departments, I'm sure, already have all of that stuff figured out. At this point, there is no guidance about how exactly an employee is supposed to go about actually requesting public health emergency leave. Unlike those other forms of leave under the FMLA, there is no Department of Labor provided certification form that companies can just outright adopt for the employees to use. And potentially the Department of Labor could come out with regulations saying that employers have the right to require employees to submit some type of certification form. But you can obviously imagine why it would be a little bit more challenging for that to happen with regard to public health emergency leave in the midst of a pandemic, because the places that would be certifying that individuals have that qualifying need to care for their children are the very schools and daycares that are currently closed. So there's a big question around how exactly the leave is to be requested. That is only one of the many issues that we expect the Department of Labor will help clarify in the coming days and weeks. As with other forms of FMLA leave, it's likely also going to be incumbent on employers to offer public health emergency leave to their employees if employees give the employer some reason to think that they have the time, that they need the time off to care for children because of the COVID-19 crisis. Consistent with the underlying FMLA regulations, employees are likely not going to be required to use some type of magic words and make a specific type of request in order to trigger their entitlement to the public health emergency leave. It's probably going to be enough that the employee just says, my kid's school is closed, I have to stay home because I have no other option for childcare. That's probably going to be sufficient for the employer to then allow the employee to take the protected FMLA public health emergency leave. So in terms of the leave that is available as public health emergency leave under the FMLA expansion, remember that it is FMLA leave. So there is a default bucket of 12 weeks of leave available. Anyone who has used some or all of their FMLA leave up to the point where they start taking public health emergency leave would therefore have less or potentially no public health emergency leave available. And that also means that in those instances where someone had already, exhausted or potentially just used part of their FMLA leave when they start needing public health emergency leave, then paid leave that's offered by the employer out beyond what's required under the expanded FMLA leave will probably not be refundable in terms of tax credits by the federal government. And again, that's the way that the current law is written. We expect that the Senate is going to be passing measures today or early next week that are designed to further provide employers with additional tax credits and other ways to help them keep employees on the payroll in order to provide these benefits. Public health emergency leave under the new FMLA expansion, it begins with a 10-day period of unpaid leave. After that point, the leave must be paid, which I'll talk about in just a minute. But during the 10-day period of unpaid leave, employees have the right to elect to use any accrued paid leave that they have available from the employer. So those of you that are familiar with administering the Wisconsin FMLA, which has a broad right of substitution, allowing employees to make that similar type of election, that's the same type of thing that the new federal public health emergency leave is providing for. Basically, employee's choice, what paid leave the employee wants to use during that 10-day period or not to use. They can choose to keep it unpaid. Also, unless we receive Department of Labor guidance to the contrary, we currently understand that employees can also use the 2 weeks of emergency paid sick leave that they are now entitled to under this paid sick leave portion of the new law that President Trump signed on Wednesday night. We believe that now employees can take that paid sick leave during the 10-day period of unpaid FMLA leave, and that employees have the right to choose whether they want to use the new paid sick leave or some other accrued paid leave from the employer, or to keep the unpaid leave unpaid under the FMLA leave. And Shannon will obviously talk more about the paid sick leave in just a minute, but there is a provision in the paid sick leave law that requires employers to allow employees to use the paid sick leave before other accrued forms of leave from the employer. So even though it's not specified in the FMLA Expansion Act, I think to be consistent with the Paid Leave Act, you have to allow the employee to choose whichever of those forms of paid leave they prefer. All right, so after the initial 10 days of unpaid leave or other paid leave as elected by the employee, the leave must be paid at 2/3 of the employee's regular rate, multiplied by the employee's normal schedule of hours. As Rob mentioned, this may end up being an adjustment for exempt salaried workers who are used to receiving either their entire salary or taking a period of unpaid leave, because this applies to both salaried full-time workers and part-time workers, that the paid leave portion of the FMLA leave is only must be paid at 2/3 of the employee's regular rate. For employees who have a varying schedule, rather than any given week's number of hours, there's a look-back period of 6 months, and the employer should take the average number of hours per week that the employee has worked over the last 6 months and multiply that by the employee's regular rate to determine the 2/3 portion to pay during the paid leave portion of the FMLA. For those varying schedule employees who have not worked for 6 months, the law provides for using the number of hours based on the employee's reasonable expectation at the time they were hired to determine the schedule that the employer should use to multiply to figure out how much to pay during the paid leave portion of the FMLA. Usually when we see language like reasonable expectation, what's going to be expected is that there's some objectively reasonable thing that we can point to say, you know, my employer told me that when I was hired I would work 20 hours per week, not just what the employee on their own expected without any basis. The amount of leave, the amount of money to be paid under the expanded FMLA leave is limited to $200 per day per employee, and in any instance, $10,000 per employee. So that means that if you've got highly compensated employees who are entitled to this leave, the only requirement is that they be compensated at a level of $200 per day, you know, assuming that that meets the 2/3 of their daily pay, and up to $10,000 total. Beyond that, there would not be a requirement under the FMLA Expansion Act to compensate those employees for as paid leave during the FMLA. There would also likely not be any reimbursement in terms of the way the law is actually written right now that would reimburse employers for anything over $200 per day or over $10,000 per employee in any instance. Like other forms of FMLA leave, public health emergency leave is job protected. So that means, in general, employees are entitled to get their job back at the end of the public health emergency leave, at the end of the 12 weeks or at the end of whatever portion they have of public health emergency leave available. The law does provide for an exception for companies that have fewer than 25 employees if the position that the employee was in is no longer available due to the COVID-19 pandemic, as long as the employer takes reasonable measures to try to put that employee in a similar position before making the determination that the job is not available. So for companies under 25 employees, you may be able to, employees may not be able to come back to their position under the FMLA as they normally would as long as the employer takes steps to try to put them in a different position if their actual position is no longer available because of the COVID-19 pandemic. All right, there is a broad exception in the law for employers of healthcare providers and emergency first responders to exclude those workers outright from receiving public health emergency leave under the law. As we generally understand it, emergency first responders are going to be your police, fire, EMT workers, workers of that sort. The FMLA regulations already provide for the definition of a healthcare provider, and I would recommend that, if you have questions about who is and who is not a healthcare provider, based on your employee base, that you look at the regulations. If you have questions, feel free to give me a call or someone else in our department. But in general, it includes individuals more like doctors, nurse practitioners, Christian Science practitioners, other highly trained individuals who have the ability under the FMLA to complete the FMLA certification form. And again, that's not, as we currently understand it, what is required to take public health emergency leave, but the definition of the expanded FMLA law, when it gives the exception for healthcare providers, it uses the exception, uses the definition from the underlying FMLA, which is related to who can and cannot fill out the serious health condition certification form. All right, so in terms of when am I required to abide by this law, the effective date of the law under the statute that was signed is within 15 days from the date that it was enacted. It was enacted Wednesday, so that 15 days would be April 2nd, 2020, 2 weeks from yesterday. So subject to clarification from Congress or from the Department of Labor, our current understanding is there is no obligation to abide by the statute until April 2nd, 2020. That also means that employees would not be entitled to take the new form of public health emergency leave until April 2nd, 2020. And that also means that it's likely, again, this is subject to potential clarification from the Department of Labor, but it's likely that any leave that is given this week or next week or before April 2nd, 2020 could not be counted against the law against the leave that employees are entitled to take under the new law once it does go into effect. So there are some measures built into the Families First Coronavirus Response Act and into the FMLA Expansion Act, more specifically, that are designed to protect employers and to help employers to comply with the new obligations under the statute. The tax credit that I've mentioned before does provide for reimbursement of up to $200 per day or up to $10,000 total for employees qualifying for public health emergency leave. I spoke with one of our colleagues in the tax department yesterday. It's still not clear at this point how exactly or how often exactly that refund will be provided. It's likely to happen at least every quarter. It's also not clear at this point how employers should be reporting this amount that they end up paying in terms of paid leave to the IRS in order to get that reimbursement. I would certainly be expecting guidance from the IRS in the next coming days about how exactly that's going to happen and how employers should track and report those amounts to make sure that they get the reimbursements to help them with the obvious issues of cash flow when trying to maintain payroll without receiving a lot of revenue right now. So please be on the lookout for that. Reinhardt will obviously be on the lookout for that, and any updates that the IRS gives us in that regard, we will let all of you know about through publishing another alert on it. It'll be also in our coronavirus response platform on our website. Another measure that the new FMLA Expansion Act takes to protect employers is it does limit some liability for potential non-compliance issues under the law. For employers that are small and so don't fall under the FMLA provisions more broadly, meaning that they do not have 50 or more employees within a 75-mile radius, those small employers will not have to face private lawsuits seeking civil damages for alleged violations of public health emergency leave. Although the Department of Labor is still permitted to bring lawsuits, those types of lawsuits are also less frequent. The Department of Labor obviously has limited resources, especially in a time like this. And so for small employers to whom the FMLA did not already apply, you should be aware that employees do not have a private right of action to claim that you are failing to interfere with their new rights under the FMLA Expansion Act, or that you retaliated against them based on using those new rights. Another way, the last way that I'll touch on that the new FMLA Expansion Act protects employers is it allows for the Department of Labor to issue regulations exempting certain companies from the obligations under the law. We will certainly watch for that. The way the potential regulation works is if the Department of Labor says that in certain circumstances, if a small company would not be able to continue as a going concern because of complying with the paid leave requirements under the expanded FMLA, then the Department of Labor could say that company is exempt from the requirements of the law. This law on April 2nd is going to go into effect before those regulations are finalized, almost certainly. So we will, again, this is another issue from the Department of Labor that we will be closely watching and provide us updates as soon as we have information on that regard. Finally, on this point, in terms of potential protections for employers, the Senate's bill that Senator McConnell introduced yesterday does provide several additional tax breaks for companies, which he has indicated on the floor of the Senate are designed to specifically ease the burden of complying with the paid leave obligations under the new FMLA expansion and the Paid Sick Leave Act. All right, so that is the majority of the presentation, but I do have some questions here that Nancy has emailed me. Thanks to the beauty of technology. Let me turn to the first one here. All right, so does the FMLA expansion change the paid versus unpaid nature of the FMLA? No, it does not change whether it does not make other forms of FMLA leave required to be paid. Someone who comes to you today and says, or after April 2nd, and says to you, I have a serious health condition, I need FMLA, that leave is still not obligated to be paid. There are regulations about substituting paid leave for that unpaid leave. However, as a default, no unpaid FMLA leave is still unpaid leave unless it is this new form of public health emergency leave after the 10 days of unpaid leave in this new section. All right, so question number 2. For ease of administration, should we pay employees $200 per day during the paid leave rather than performing the calculations? I think no, because that may be certainly more than you may be required to pay employees, but also you're likely going to be required to run the numbers for these employees, because in order to seek any form of reimbursement, you're going to have to do it along the same lines of what the tax provisions allow for. And the tax provisions only allow for reimbursements up to the amount that the employer is required to pay under the expanded FMLA paid leave portion for any given employee. All right, so the last question that I'm going to have time for today before I turn it over to Shannon is a very good question that we've talked about internally, and I think is still going to be a conversation going forward. But are there circumstances in which intermittent leave will be allowable as public health emergency leave? I have read that early versions of the House Representatives bill did indicate that intermittent leave was not required for public health emergency leave. There is now nothing in the law indicating one way or another, and we shouldn't extrapolate from that absence that it is definitely required. However, we should not assume that it's not required. The FMLA regulations about intermittent leave do limit the circumstances somewhat. Again, this is FMLA leave prior to COVID-19 did have limitations on when an individual could take intermittent leave. For instance, someone could only take intermittent leave for a serious health condition if the intermittent nature of the leave was itself medically necessary, and that medical necessity was itself signed off on by a healthcare provider. Similarly, the FMLA regulations limit intermittent leave for birth or adoption to instances in which an employer agrees to provide intermittent leave for birth or adoption. So this is yet another instance where we likely need Department of Labor guidance about when employees are entitled to take intermittent leave, when it's appropriate to take intermittent leave. Obviously, it would become pretty unmanageable if someone had to establish each individual day what portion of their day they were required to take care of their children due to COVID-related issues. So obviously, this becomes pretty complicated, as you can imagine. But at the same time, until there is guidance to the contrary, we also cannot assume that intermittent leave is not going to be required. So it's certainly an issue that we expect to see some developments on in the future. If you have questions about a particular question that you're facing, feel free to contact me or one of the other Reinhardt attorneys. We will do our best to help sort it out. And like I said, we will keep you all informed the best we can through our e-alerts. So please sign up for those if you aren't signed up already, and go to our website where we have COVID-19 Resource Center where you can learn more information. So at this point, I will turn the presentation over to Shannon, who is going to talk about the new paid sick leave requirement under the Families First Coronavirus Response Act. Thanks.
Thank you, Michael. As Michael highlighted throughout his presentation, we are still waiting for both FMLA and the paid sick leave on guidance from the Department of Labor. So like Michael, I do have some overview and guidance for employers, but a lot of this is predicated on what the Department of Labor is going to do. And we are, as I'm sure you all are, eagerly awaiting those regulations. But as Michael mentioned, we might not see the regulations potentially until after the bill as of now, is slated to go into effect in April. So this paid sick leave portion is an entirely new set of leave. So it is not, it's separate from the FMLA expansion. The paid sick leave applies to employers with fewer than 500 employees. And unlike the FMLA portion, there's no requirement regarding how long an employee has been employed. It provides 80 hours of paid leave to full-time employees, and then for part-time employees, the number of hours that they can take is calculated by looking at the average amount worked over 2 weeks. And unlike the FMLA as well, there are many more circumstances under which an employee can take the paid leave. I'm going to go through those circumstances now, but I just want to lay out for employers that they're basically in two categories, which is the employee is directly affected by the coronavirus, or the employee is caring for somebody who is also affected by the coronavirus, either by closings of schools or because the person has some sort of symptomatic response. So I'll go through all 6 of the requirements now. The first is that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The second is that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The third is that the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Fourth, the employee is caring for an individual who is subject to an order as described in the first instance, so federal, state, or local quarantine or isolation order, or the individual they're caring for has been advised, as described in the second condition, which is they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The fifth condition is the employee is caring for their son or daughter, because their minor son or daughter, so that's son or daughter under 18, because that minor child's school or place of care has been closed, or the child care provider of that minor child is unavailable due to COVID-19 precautions. And I do just want to point out the definition of child care under the paid leave portion is somebody who is regularly compensated to provide child care. So, grandparents, aunts, uncles likely would not qualify as a child care provider for these purposes. So employers should be aware that even though an employee may have help from a relative, that probably doesn't disqualify them for this paid leave. And then the sixth condition, which appears to be somewhat of a catch-all condition and something that I'm hoping the Department of Labor will clarify for employers, is that the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. Again, it's not entirely clear what the law means by this. We hope the Department of Labor provides us some sort of guidance soon. So, how do we calculate leave under the Paid Leave Act? So the first 3 conditions, as I mentioned, have to do with what the employee is experiencing personally in direct relation to COVID-19. For these first 3 conditions, an employee cannot be paid more than $511 per day, and that's $5,110 in total. So the rule is that you are supposed to pay the employee their full salary if they meet conditions 1 through 3. However, as I just mentioned, there is a cap on the amount that employers have to pay those employees. It is higher than the FMLA provision, likely because, well, I shouldn't say likely because the law doesn't exactly explain why it is higher for those employees. However, employers should be aware that there is a higher payment threshold. However, for the last 3 conditions, so the ones having to do with the employee caring for somebody else or the more broad catch-all provision, it's the same payment structure as the FMLA leave. So it's 2/3 the employee's regular salary, but it is capped at $200 a day or a sum of $2,000 per employee in total. So there are differences in what employees can collect under the paid leave. Also, like Michael mentioned, the FMLA does exempt certain healthcare professionals, slightly different from the FMLA. The paid sick leave has a provision that allows the Department of Labor to issue regulations opting out healthcare providers and emergency responders. So unlike the FMLA, which has that provision baked into it already, the paid sick leave, it's not yet clear whether you can actually exempt healthcare providers and emergency responders. Again, we really hope the Department of Labor provides some guidance quickly, because as soon as this hits, I know that employers are going to have a lot of trouble, particularly in the healthcare profession, with navigating leave for those employees, particularly since the healthcare providers and emergency responders are those of us that are going to be the hardest hit by the COVID-19 pandemic. The paid sick leave provision does have a requirement that employers post a Department of Labor issued notice within 7 days of the department issuing that notice. So the Department of Labor has not yet published a notice, and this would be similar to something that you're already required to put in your workplace. So, you know, an FMLA notice or an ADEA notice, this is just yet another notice that you need to post. And like those other notices, you'll need to post it in an area where employees are very likely to see it. Again, we're still waiting on the Department of Labor to issue this notice. It likely won't be issued for probably until next week. As soon as it is issued, though, we can notify employers. We will likely, as Michael said, be putting out more e-alerts on this topic. So it will be one of the things that we will continue to monitor as the situation unravels. Excuse me. In terms of notice requirements, so it's different than the FMLA portion that Michael touched on. Here, after the first workday or portion thereof that the employee takes paid leave under this provision, an employer can require an employee who is on paid leave to follow reasonable notice procedures to continue receiving paid sick leave. We don't know what a reasonable notice procedure is under this law. I think that's something that Congress punted to the Department of Labor in this instance. You know, I think this is something that employers will really be relying on as you're administering paid sick leave, because you do want to ensure that your employers, you know, we don't want people to take advantage of benefits, of any benefits, and we, you know, particularly don't want people to take advantage of paid sick leave when this is something that is going to cost employers a lot on the front end. So as soon as we have more information about what that reasonable notice procedure constitutes, we will definitely share that information. One thing that I do want to touch on, and I believe we've gotten some questions on, is does this apply to leave that I'm giving now? So say I start following this law and I say, okay, well, I'm going to pay you your regular rate up to $511 because you're subject to an isolation order. We understand that the law does not apply retroactively. I believe Michael touched on this for FMLA. The same goes for paid sick leave. So if you are paying for paid leave right now, you likely will not be able to get tax credits for the paid leave you are currently administering. As soon as the bill goes into effect, which again, as of now, we think will be April 2nd, but subject to change per Congress or the Department of Labor, you know, that's when the employer can start starting the clock on when they can receive tax credits and how much they can receive for those tax credits. One thing Michael mentioned, and then is another outstanding issue under this bill, which I'm sure is something employers love to hear, that there's no solid guidance on this. There is no mention of intermittent leave anywhere in the Paid Sick Leave Act. As Michael mentioned, the FMLA the regulations already have some deal with intermittent leave. We're not exactly sure how those regulations interact with the FMLA just yet. However, this paid sick leave provision is an entirely new thing that, as Rob Sholl mentioned, has never been seen before and is an entirely new territory for employers and employees alike. As of now, we understand that there likely cannot be intermittent paid sick leave, subject to, of course, the Department of Labor saying otherwise. Of course, as Michael said, absence of no intermittent leave does not affirmatively say one way or the other whether or not an employee can or cannot take this intermittently. However, the purpose of this paid leave is to help people who are seemingly unable to work because of circumstances coming up in their life. So at this point, we would advise that it is not taken intermittently. However, again, subject to change based on regulations. Nancy, do you have a question?
Yeah.
Perfect.
That was another one that several people have.
Sure. Oh, so this is a good question. There are 6 conditions to qualify, but, oh, sorry.
I need the list repeated slowly.
Oh, they need, okay. Sorry, I will repeat the list one more time. I thought what they were asking is whether or not somebody could qualify for one condition and take 2 weeks of paid leave, and then qualify for a different condition and take 2 weeks of paid leave. That is not how I would interpret the law at this point, but I will read the list slower. So condition number 1, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Condition number 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Condition number 3, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Condition number 4, the employee is caring for an individual who is either subject to federal, state, or local quarantine or isolation order related to COVID-19, or the individual has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Condition number 5, the employee is caring for a minor child if that child's school or place of care has been closed, or the minor child's child care provider is unavailable due to COVID-19. 6, the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. These conditions are also laid out on Reinhardt's website in our COVID-19 Resource Center. We issued an e-alert about the signed final version of the bill. If that still wasn't slow enough for people to take down, you can access those conditions there. One thing I do want to flag 2 things before we move on to the rest of the questions that, as I was reading the list, occurred to me that employers might have questions about, and not necessarily things that we have answers towards, just something I want to flag. I understand that California just implemented a very restrictive order where it's telling people to stay in their homes except for essential needs, so going to the grocery store, etc. Whether or not that is a state-mandated local quarantine or isolation order is something that I hope we get guidance on from the Department of Labor, particularly given that in the next couple of weeks, we are likely to see more and more states follow that. I believe New York was talking about, or maybe has implemented, a shelter-in-place order. Also potentially something that could, if you read the statute broadly, potentially be an isolation order. Excuse me. The second one, the employee is experiencing symptoms and seeking a medical diagnosis. There is an issue with testing being unavailable right now. Anecdotally, in my own personal life, heard of people, not that I'm personally acquainted with, but just in the general Wisconsin population, who have gone to a doctor and requested a COVID-19 test and have been rejected because they are not in a high-risk enough group, but they are experiencing the symptoms of COVID-19. This, seeking a medical diagnosis, what that means to the Department of Labor is hopefully something we get clarification on. Something else that I wanted to point out is I did read an article this morning about the company Everlywell, I believe, may be having the capacity in the next few weeks or next week to issue privately issued COVID-19 tests that people can take at home. So I am hoping that this issue starts to resolve itself, but just keep in mind that there may be people who are experiencing symptoms and attempt to seek a medical diagnosis, but perhaps cannot get that medical diagnosis because of the limited testing available in the state of Wisconsin and, frankly, across the United States at this time. This first question I already addressed. What if I offer coronavirus-related paid leave for the bill passes? As we understand it, the bill does not apply retroactively, thus the employer would not qualify for the tax credit relief for that time paid up until April 2nd. Second question, I am a seasonal employer who at times satisfies the 500 employee threshold. How does this affect me? As Michael mentioned earlier, our understanding is that do you have 500 or less employees at the time this leave is being distributed? Department of Labor might tell us there's a different way to calculate the number of employees, but as of now, that is the most reasonable way to interpret the statute. Finally, what happens if some of my employees don't qualify for paid leave? This is something we anticipate a lot of employers will deal with. One option is to just operate under your standard paid leave policies if you have them, or other leave policies. Another option could be to offer temporary leave that has slightly different conditions. So if, as you likely noticed, the 6 factors don't include people who are at higher risk to develop COVID-19. It could be possible to institute temporary PTO that you offer to your employees, where you require an employee to bring in a signed doctor's note that says, I am at higher risk of contracting COVID-19, and then providing them temporary additional paid leave that way. This is something that is obviously on a case-to-case basis, and something that we would highly encourage you to consult with your attorney about, just because depending on the nature of the situation, the nature of your leave, as it currently stands, the solution will be different for every employer. That's all I have at the moment. I believe we're going to move on to Jesús.
Thank you, Michael and Shannon. And as Shannon mentioned, Jesús will talk next and is the last portion of our presentation today.
Thank you much, everyone. Hey. All right. Thank you, everyone. I really appreciate the opportunity to talk about what the Equal Rights Division and really the whole Department of Workforce Development is doing right now to make sure that we're providing services to the public under these conditions. You've gotten a lot of great advice and thoughts today from the attorneys here. I want to pause, though, real quickly, just give everyone a chance to breathe. While I point out, I understand the majority of the people, or at least many of the people on this call, are HR leaders, and you deserve a shout out under these extraordinary conditions. Having worked in this world, I have a great appreciation for all the work you're putting in around the communication, around the change management, around dealing with some people who are very scared in some cases, very concerned about what's going to happen, and there are a lot of questions popping up all the time. So respect, see the work that you're doing, and really do appreciate it. what I want to do with my time is start by talking a little bit about specifically our services at Equal Rights Division. That's going to be most relevant to those of you who have cases pending, so that you know how we're operating. But then I'm going to talk more about the Wisconsin laws that we enforce and how they're playing out in this situation. I'm not going to retread a lot of what you've already heard, but there may be a few things that I can emphasize a little bit from our perspective at Equal Rights Division. But first, talking about our services and how we're proceeding right now. Obviously, I think we're balancing what many of you are also trying to balance. On the one hand, we care a lot about the health and safety of our employees, and we want to protect them from infection, protect their families, and protect the public. But of course, we're balancing that with our need to carry out our mission and carry out our work and serve the folks that do need our assistance, and to find that balance so that we can do both as effectively as possible under these circumstances. So here's how it's affecting my division, the team that I oversee. First, with regard to walk-in services for individuals, when we have individuals who have questions or complaints that come physically to our offices, we are no longer taking those walk-in services because again, as I mentioned, we're trying to protect the health and safety of our employees. So those folks that are coming in our doors at our Milwaukee or Madison offices, we're taking their contact information and calling them back, and we are asking all folks to contact us through the phone and through the email service that we have. So we are still getting, of course, quite a few calls. We're getting quite a bit of email as well. Some of those are complaints that are getting filed, and yes, our investigations process is still ongoing. Our staff, all our investigators at this point are working from home, but they're fully connected, so we are still able to receive those complaints. We are still able to process them and move them through as quickly as we can. Deadlines still do apply. We recognize that the circumstances may make things difficult to get responses or information as timely as you might normally. In those situations, we ask that you be very direct with your investigator about what's going on. Understand that we're still trying to move things through expeditiously, but these are rather extraordinary times. Do keep in mind that those deadlines still apply, and communicate if you're having trouble meeting those deadlines. Also be aware that the FML cases that we have, the family and medical leave cases, by statute are on an expedited schedule. If we see an uptick in those type of cases, which is certainly possible under these situations, you're going to find that those cases are moving through much faster, and just be aware of that that's part of our process and something we have to be aware of. With regard to hearings, so if you have a case that's in a hearing, at this point in time, and something we've all heard many times, the situation is fluid and is rapidly evolving. But at this point, we are still conducting hearings, but with the understanding that many of our hearings are in fact getting postponed. In some cases, it's because parties or witnesses, key witnesses in a case, are not available due to health reasons or changing circumstances. And frankly, in some cases, it's because the hearing locations themselves have been closed. And without a hearing location, we need to postpone the hearing until a location can open or can be found. The ALJs retain the discretion when that happens to decide what's going to happen. So the best thing you can do for us is, if you find you're not going to be available or a witness is not going to be available, to communicate as soon as possible with that ALJ. In some cases, ALJs may allow for phone testimony, but because of the nature of the hearings that we have, in many cases, that's simply not possible, and postponement happens instead. So, short version of that, at this point in time, yes, we are still conducting hearings. However, we're seeing hearings fall off the calendar, and that is a fluid situation, so be aware of that. Finally, mediations. We conduct mediations by phone, and now we are doing all our mediations by phone. Especially if you have a hearing coming up and you're concerned about what's going to happen with that hearing and trying to find that resolution, this may be a great time to give a second look at whether you want to pursue mediation with one of our ALJs. We have a very good success rate with those cases that go to mediation. And again, we can conduct that mediation with all parties by phone. So we are encouraging you, if you have a case and you're trying to figure out what to do in this, really take a look at our mediation option as an alternative to having to come in, having your witnesses come in into a physical space to conduct a hearing. It's probably going to get things resolved a little faster along the way. So that's a lot of how it's impacting our processes. Let me switch over to talk about some of the legal issues. And again, you've already heard quite a bit of this from the attorneys here at Reinhardt on this, and I'm not going to repeat a lot of that, but I do want to underscore a few things. First, let me talk a little bit about employee leave. And you've already got a lot of coverage on some of the new leave that's out there, as well as just thinking through how FMLA applies. Here's the thought that I want to give you. Most of the complaints that seem to come in or seem to arise from FMLA violations, they tend to come from either miscommunication about leave rights or employee misunderstanding about what those rights are. And they also come from inconsistent enforcement of FMLA rules. And a lot of that, by the way, doesn't just apply to FMLA, but all sorts of employee leave. We're in a dynamic situation where there's a lot of new information out there. So what I'm trying to stress is the importance of clear communication about what the expectations are, making sure that your frontline supervisors understand what's to be communicated and how those rules are enforced, and making sure that your employees understand, even as things change, that they have that information. Making sure that everyone kind of knows, here's what to expect, here's what your processes are, is going to do a heck of a lot to prevent any kind of issues from arising before my division that you're then going to have to wrestle with. So everything you can do to make sure that those messages are getting across, that your frontline supervisors understand that and aren't miscommunicating those messages, or aren't enforcing, and making sure they're all enforcing your rules in a very consistent way is really important if you want to mitigate against potential liability and all of that. I would say a couple other considerations specific to the circumstances we're in. One is making clear the difference in your organization between what is considered leave and what's considered work at home. That admittedly can blur, especially as employees are working at home and suddenly find that they've got a household full of kids at home that they also have to manage and figure those things out. But there is a difference between an employee going on leave when he or she is not actually performing work versus when they are at home, working at home, perhaps on reduced hours and things along those lines. So thinking through that and then making sure that that's part of the communication and clarifying things is going to help alleviate, I think, some issues that may come up when an employee thinks that they may be on leave when in fact the expectation is that they are working at home, or vice versa. The other thing to be mindful of is the consistency of enforcement, and especially in times where situations change. What we were thinking of last week, maybe in terms of here's how we're going to manage leave in these circumstances, may change in the next few weeks depending on your business circumstances and other factors. So even if things change, get in front of it as much as you can, give as much notice as you can to your employees, and be very clear when things in fact are changing. And then in general, I would say as far as managing leave under these situations, set clear expectations, be clear in your communication, and do be clear and consistent. But I would encourage everyone, too, to be patient and compassionate. Part of where the patience, I think, applies in this space is that we're hearing anecdotally that individuals who normally would need some medical documentation to justify leave, for example, are not in a position where they're able to get it. As we know, many of our medical facilities and practitioners are a bit overwhelmed. Information is slow going. Now is not the time for you to be insistent on meeting hard deadlines on providing certain medical information. It's just going to end up frustrating everyone and creating those situations that you want to avoid in terms of liability. So be patient, be compassionate, but yes, do be clear in your expectations and communicate to your employees as well as your supervisors to make sure everyone is on the same page. Let me talk a little bit about non-discrimination, and it ties in to leave. And as you're handling all these different issues about who's working at home, who has what work expectations, and how you're doing leave, you've already heard a lot about how this applies in disability cases and in age situations. The general message, though, is this: enforce your rules evenly. And if you are enforcing them differently for different groups of your workers or different job duties, be clear that that's where the differences lie. Make sure that you're communicating about what those expectations are. Another tip I would give you, and this is a general tip I've given even in non-pandemic situations, justify your actions on the front end. At the time that you make a decision or employment decision about who gets leave or who gets what assignment, do that on the front end. Don't wait until the back end to justify exactly what you're doing. So that's a good practice here as well. Think through it before you actually take action. Thank you. Sorry about that. I'm really bad about remembering to advance slides during a presentation, so thank you, Nancy, for that. The other thing that I do think it's worth bearing mention, as of 2 days ago when I took a look at it, our agency has not yet received complaints specific to harassment or discrimination directed at Asian employees. But anecdotally, there's a lot that's out there in the news and even locally that under the circumstances with coronavirus, there are jokes, there are comments that are being made that many of our Asian colleagues and friends can find offensive. Just like in any other situation, you need to be wary in managing those things and staying on top of it. We certainly are, and hopefully we're not going to see any complaints because we're all going to realize that that's simply inappropriate. Let me talk about child labor next. It may seem odd that we're talking about child labor and child work permits with all of this going on, yet I will tell you that it's one of the biggest questions that we received at the beginning of this week, and that's because folks who were looking for child work permits were finding that many of the work permit centers, many of which are located inside schools, are closed. And so those minors that were looking to get their work permit and do some work were not able to get those permits. So we're getting a lot of those questions, in addition to getting questions about whether some of those children are able to work with the schools closed in some situations. So we're still working through the question of making sure that those who qualify for work permits have a way to apply for them. At this point in time, and again, changing situation, so this is as of right now, but we are still accepting work permit applications at our offices in Milwaukee and Madison. But really the main 2 points that I want to raise with regard to child work permits. Number one, even though schools may be physically closed, many of our students still have expectations in terms of attending virtual classes or doing learning online. We still consider that to be a school day, even if it's not happening in the school. And those students would still be under the same restrictions in terms of their ability to work that they would be during a regular school day. So want to be clear on that. And the second point that I want to make with regard to that is not to forget that our job centers are still open, the DWD job centers, and there are an awful lot of people that have suddenly found themselves unemployed and hoping for work and hoping for some source of income during that time. So if you are thinking about how can I staff whether it's a grocery store, whether it's some other need, where you might under normal circumstances be looking at bringing minors into the workforce, I would encourage you to take a look at the services that we can offer through the Job Center and connecting you with some of those workers there. Rob already talked a lot about some of the wage and hour things. Just a couple other things I want to emphasize. Number one is not to forget that even as you're going through all these changes and you've got work at home situations and you've got different leave situations, not what you would typically manage, don't forget that there are still reporting requirements. There are still time recording requirements with regard to all of that. So don't forget to think through making sure that you're recording when people are working and that you're clear with your employees to make sure that time is still getting recorded and that you're staying on top of that. That's going to avoid potential issues down the road. Along those lines, it's a good practice to clarify what are work hours when people are working at home. For example, as a parent, I have to be mindful of whether I can work with my kids running around in the background and making sure that they can pour the cereal for themselves or whatever may be the situation. So making sure that your employees know when they are not working because they're engaging in other duties and when they are working so that they can track those times accurately, again, will help down the road potentially as you run into those issues. I know we're in different times than we would normally be in, but this is one of those things that can easily slip through the cracks if we're not thinking about that as we're putting more of our workforce out and working at home. Two more issues that I want to raise around kind of wage and hour related concerns. One is around the topic of employee misclassification. You've heard us talk today about unemployment and talk about workers' comp. Those are things, of course, that clearly apply when you have employees. If you have a workforce where you have non-employee workers that are working for you, and there are questions as to whether, in fact, they should be classified as employees versus independent contractors, keep in mind that if they are not employees, the practical impact on that part of your workforce may be that they don't have the protections that your employees have in terms of unemployment or potentially in terms of workers' compensation. The short of which is now is not the time to misclassify employees. And if you have questions on that, work with your legal counsel. Let's make sure that our workforce has the proper protections that they need. Let's make sure that you're protected as well if issues do end up arising. So be mindful of that misclassification issue. Finally, on this topic of wage and hour type implications, and it's tied into work at home, it's an issue that's particularly important to me, and that's being mindful of domestic violence situations that your employees may be facing. Working at home is a wonderful, flexible thing for many employees and for us as employers, but keep in mind that there are some employees in your workforce for whom home is not necessarily a safe place to be. And I've seen anecdotal evidence that there is a rise in domestic violence complaints happening, and it seems to be tied into more people working at home as well as the general stress that people seem to be under. All of which is to say that when you're deciding whether you're sending people at home, if you have an employee that comes forward and expresses concerns about how that may play out, be mindful of that. And there are various services around the state that may be able to provide support or alternatives for those employees. So please be aware of that. Let me talk a little bit about the plant closing notification. You already heard a lot about that, but we are getting a lot of questions about what happens there. I can't give you any sort of blanket declaration that these are unforeseen business circumstances. That's something that we do look at case by case. We do want to make sure that if there is a situation where someone suffers harm or injury and they weren't notified that their plant was closing, that it's really due to unforeseen business circumstances and that in fact it may not be something else. be aware that you do need to give notice, and you need to give notice as soon as practicable. So if you become aware of a need to close part of your operations or to close your operations, give the notice as best you can. As the attorneys mentioned, it is a defense to say that these are unforeseen business circumstances, and clearly, for many of us, we are facing unforeseen business circumstances. How it actually plays out in the event of a closing or a layoff, that's going to be something that we're going to have to look at if that issue comes in front of us. But it is very good advice to give that notice as soon as practicable if you find yourself in that situation. One other point. Sorry, I was taking notes during the presentation earlier. The EEOC pandemic guidance is a great source of information, so I do recommend you take a look at that. As you're communicating about all of this, one additional communication I would make sure you make to your employees is making sure that they understand the process for requesting accommodations. So if you have an employee who needs a medical accommodation in these situations and is asking for an alternate work arrangement, make sure that you're clear about how that happens so your employees understand. Finally, let me talk a little bit about resources, and you'll notice this is a very succinct slide with one website, and it is one website because we are at DWD, we are compiling all the FAQs and a lot of the resources onto this single website. So if you go to the DWD website and look for the COVID-19 section, you're going to get a lot of information, not just about the Equal Rights Division, but also about all our various divisions, unemployment, workers' comp, education and training, vocational rehab, to understand what's still available, how to access those services. Are job centers open? Are they closed? The governor has a website as well. But really, this is a fantastic resource. We're updating it regularly. If you are one of our devoted followers on Facebook of DWD or LinkedIn, we are updating information there as well. Now may be a good time to subscribe to make sure that you're getting that coming up right there. We do have staff at Equal Rights as well as everyone else who are working, manning the phones. If I can make any ask of you as you have questions, because we do want to help, we want to answer them, please go online first. As you can imagine, we're getting pretty overwhelmed with calls right now from all sorts of things. So you would help out our staff and maybe even get an answer faster if you start out with this website and see what's there before just calling our office. We're happy to help, but it really would save us quite a bit. Nancy, do I have any questions that are coming in?
Actually, quite a few questions coming in.
Excellent. Well, and again, really want to be able to answer them. I don't know how many I can answer on this webinar, but that's why we've got the website. Okay. Sorry, swallowed water wrong. Not a virus. First, are DWD job centers still open and providing services? The good news is yes, we're keeping them open as much as possible. However, some of our locations have closed because of where they are located, and if the building has closed, then some of those job centers are closed. So if you go to this COVID-19 website on DWD, there is a list that we are keeping updated in terms of what sites are open and what's not. Be aware that we are, of course, taking social distancing and other precautions to make sure that the folks that we're serving remain healthy and uninfected as much as possible. But we are committed to making sure there are a lot of people that are looking for work, and we know there are a lot of employers that are facing work needs that they need to fill urgently. So whatever we can do to help, we're doing our best to try to do. Next question. Can you talk about DWD's WorkShare program? WorkShare or short-term compensation, I'll be honest with you, I'm not a subject matter expert, so I'm going to give you just I can give you kind of a quick overview of what that is, what WorkShare is, but otherwise I'm going to direct you to that website for more detailed information. There's a fact sheet and there's ways to connect with folks who are subject matter experts and might help. But the short of it is that for many employers, this may be a way to avoid layoffs or shutdowns, and find a way to help those folks retain some income and even keep their health insurance, even as things do slow down a bit. So the general idea of work share is that for employers who reduce work hours uniformly across a particular work unit, and it's pursuant to an approved work share plan. So there is sort of an application process to make sure that this is being done according to a plan. But in those approved cases, those employees can get partial UI benefits even while they're continuing to work. So for many in our workforce, that's a very good way to be able to continue working, even if the work isn't there at the same level. And for employers, you get some benefit of having that shared income. Again, that's a really quick general overview, and I really encourage you, if you're thinking that may be a solution for some of your needs, take a look at that website, take a look at that fact sheet, and it should be helpful to you. I really appreciate the time that Reinhardt's given me to be able to share some of this information. We're looking forward to help. When you talk to our staff, please be extra nice to them and extra patient. They're really working hard. They care a lot about their job, and they care a lot about the people that they're serving. So if you have a chance to talk to them, please thank them for the service that they're continuing to provide. Thanks.
Thank you, Jesús, and thanks to all of our speakers today. This program was put together on really short notice in an environment where a lot of the information is changing rapidly. So I really appreciate the efforts of everyone today, and appreciate the efforts of our marketing group who put this together on short notice too. We apologize to anyone who had technical difficulties, but given the time frame, there wasn't a lot of time to test things out, so hopefully it worked well. One other thing I wanted to mention is I know there are many questions that were submitted that we did not get to talk about specifically during the program today. We tried to cover some more general ones that came in, but to those of you who have other questions, we will try to address those with you, respond to either with a phone call or an email as soon as we can. You can also look at, in addition to the EEOC and DWD resources that were mentioned today, there is a coronavirus resource center on our website that goes through the new legislation and some other topics that we covered today. So feel free to look at those as well. And I want to thank you for those who participated today. We want to be a resource for you and help you through these challenging times. So I appreciate the fact that you've taken some time to go through this, and hopefully this has been helpful, and stay safe.